Welcome back to the program. It's the Vicki McKenna Show, and Luke Berg from the Wisconsin Institute for Law and Liberty joins me on the program to talk about, well, I guess, being forced to go to court to get schools to follow just the law. It's good to have you, Luke. Thanks for joining me.
Yep. Thanks so much for having me on.
So what we've got here, it looks like Milwaukee Public Schools in violation of, I'm going to say this, existing law. This is before Trump was elected, creating forms to, encourage kids to declare alt gender and then hiding that from parents. Tell me exactly what you found out.
Yeah, this is another one of those policies of school districts to hide gender transitions from parents at schools. And unfortunately, this has become far too common. We've seen lots of both Wisconsin school districts and school districts nationwide who have these policies. So this is the Milwaukee School District. And like other school districts, they have a policy that says minor students of any age can change their gender at school. They can change their name, pronouns, start using different bathrooms, all without notifying the parents or obtaining their consent. And what people frequently ask is, well, how in the world does a school implement this and hide it from the parents? So they actually have some forms that they use in the Milwaukee School District that's called a gender support plan form and a gender communications plan form. And it asks a bunch of questions, what name do you want to use, what pronouns do you want to use, what bathroom, and then are your parents aware? And if not, what are we going to do about it? And at the very top of the form, it says confidential and directs staff to put this not in student records, but in a confidential file. This is a pretty straightforward and blatant violation of what's called FERPA, the Family Educational Rights and Privacy Act, which generally gives parents access to their children's education records. So the district is attempting to hide this from parents by keeping it out of student records and putting it in this confidential file. And then there's a second federal law called the PPRA, the Protection Pupil. I actually don't remember what exactly it stands for, but it's the PPRA, and it gives parents generally right to notice and to opt out of evaluations and surveys conducted on their child. And certain type categories of information are covered by the PPRA, and that includes negative attitudes toward parents, if they're struggling with any mental health issues, and their attitudes and behaviors regarding sex. And we think the way the form is constructed pretty clearly falls within the ambit of the PPRA, and it's clear the district has not provided parents with notice and a right to opt their children out of this form. And so these forms violate both FERPA and the PPRA pretty clearly. And in prior administrations, the Department of Education wasn't enforcing these federal laws, but the Trump administration came in and made it a priority to protect parental rights by enforcing these laws. And so we have filed a complaint with the Department of Education asking it to investigate the district.
All right. So FERPA on its face says you're supposed to give parents information. And then this other federal law that already exists, and I looked it up, it's a Protection of Pupil Rights Amendment that gives parents explicit access to mental health, sexual, et cetera, information about their kids. And the Milwaukee Schools has gone out of its way to create a confidential system where a 12-year-old, a 13-year-old, a 14-year-old kid can just decide one day to be alt gender, and mom and dad never get that information. And then they can't even demand the information and have the district supply the information.
Right. And that's the problem, is the parents whose rights are being violated don't even know it because it's being hidden for them. And even if they were to be proactive and ask for records, they wouldn't get it because it's directly put in this confidential file, and that's the problem.
So this is two federal laws that the district already knew it was violating. That blows my mind. So this is before Trump's executive order. The district knew it was violating these laws, but nobody could actually bring a claim unless you knew that the district knew it was violating these laws. So good you found out. But now with the backdrop of the executive orders, be it the executive orders on the Department of Education to investigate this stuff, the penalties that are going to be associated with continuing to promote this stuff, how many, I'm asking about Milwaukee, but surely they're not the only one doing this.
No, not by a long shot. There's a group called Parents Defending Education that has been documenting the number of school districts that have policies similar to this, and they've already documented 1,200. So this is stunning in scope how broadly school districts have implemented these policies, and this is a big problem because some courts around the country have held you can't sue over this, even though it's a clear violation of federal law. You can't sue over this unless you can prove that your rights have been violated as a parent. But the problem, of course, is the parents whose rights have been violated don't know it and can't find out. And so, I think those courts are wrong to say that parents can't sue preemptively to halt this kind of policy. And not every court has said that, but some courts have said that. So it's a big challenge in the litigation. So it's hugely important that the Trump administration has said we are actually going to use our enforcement authority to enforce this federal law, and they can do so preemptively, and they can investigate the districts, and they can find out which parents' rights are being violated. And one of the things we've asked them to do is to force the school district to notify those parents so that they can know what's going on with their kids at school.
Well, I'd also like to know how many kids have had this information hidden from their parents. I wonder how many times it has happened. Obviously, we can't know, right? You could submit a FOIA an ORR, and you wouldn't get the information. You could submit a FOIA to Department of Education, and you wouldn't get the information because they don't know either. No one has a record of how many of these kids, right? This is all sort of super secret stuff that only the Milwaukee school administrators know, and no one else does.
Yeah, that's exactly right, and that's the huge problem. We actually brought a lawsuit against the Eau Claire School District for a similar policy. It was on behalf of an association of parents, so a bunch of parents with kids in the district. And the main argument was, you have this policy. We don't know if we have been targeted by this until we go through this lawsuit. And the federal courts dismissed the case and said the parents don't have standing because you haven't proved yet that you were affected by the policy, again, which I think is crazy and wrong. But that's what some courts are holding. And so it creates this roadblock in the litigation. So that's why I think the federal investigation will be so important, because the Trump administration can get this information, and I hope they will.
So that's the problem, is that your parents... that blows my mind. The law is being violated. It's clearly being violated, but the people who would be harmed by it don't have standing because their rights are being violated. They don't know it, and they can't get the information to bring it to court in the first place. How's that justice?
It's crazy. And it's honestly, I haven't been able to come up with another single example where the federal government has a policy where on its face, written into the policy, you could just read it. It's a very clear violation of federal law. And then they say, oh, by the way, when we're violating your rights, we're going to hide it from you so you can't find out that we're violating it. I mean, that's a very unique situation.
When you find out, you can't sue because we're still not telling you how your rights were violated there. All right. So the whole idea is to get the Department of Education, the Department of Justice to come in, get the information. Is there a way to get this statewide? Is there a way to do this sort of holistically? Because you're playing whack-a-mole, Luke. And they want you to. Every time somebody has to give you information on the sly so that you can get the information to take these actions.
Yeah, well, look, obviously the hope is if the Trump administration continues to be aggressive in enforcement of FERPA and the PPRA, hopefully it will send a message to other school districts and persuade most, if not all of them, to change their policies. Obviously, there's going to be some who dig in their heels and don't. And I think, the litigation half of this can continue to have an effect and a role. I mentioned we had sued the Eau Claire School District. We've sued two others, both Kettle Moraine and the Madison School District. But there's also 35 to 40 other of these lawsuits around the country now by other groups. Because this is so pervasive and so obviously wrong. And so I think that those cases eventually are going to reach the U.S. Supreme Court. And I hope we get a pro-parental rights ruling from the court. I think it's a pretty egregious and blatant violation of parental rights. So eventually, I hope this will be solved nationwide, but it's going to take a while. It is a bit of a ground war.
Yeah, you've got this sort of 1-2 puncher. You've got a FERPA violation, and then to back your claim that it's a violation, even though it's a violation on its face, is this PPRA law as well. And is Madison, Kettle Moraine, or any of the other school districts you're aware of, have they changed their policy?
Well, so the Kettle Moraine School District, we actually won our lawsuit, and the court held that a policy like this was a violation of parental rights. And so, yes, the Kettle Moraine School District since chose not to appeal, changed its policy, and now requires parental consent before students can change their name and pronouns at school. So that was a win. The Madison case, all of our plaintiffs, we actually had 14 parents sue the school district. The case was litigated for like 4 years, and during that time, COVID happened, and every one of our plaintiffs left the district. So the case got mooted before we ended up getting a decision in the case. But since then, the Madison School District has taken the policy off its website and responded to me in response to an open records request that they no longer have a gender support plan form. So I don't know if they're still treating children as if they're the opposite sex, using new name and pronouns without using a form, without having a policy on their website. I suspect they are, but they at least recognize that they were at risk of a violation of federal law because their prior policy had the same thing as Milwaukee's and was a pretty clear FERPA violation.
So, this makes me want to say, if you are aware, you need to reach out of a policy like this at your kid's school. And just because you're in a, like Kettle Moraine, you would have thought, well, I probably don't have problems in Kettle Moraine, right? Don't think that way. It's pretty good idea that there's something that is about pushing this stuff because it's being promoted through DPI in Wisconsin. But, the idea that they can violate federal law secretly if you have that information that these forms exist where parents are being foreclosed from knowing their, the mental health and the sexual health information about their kids. I don't even know what the argument for that is, except that all parents are child abusers and therefore we can't tell any parent anything. I mean, what would they argue? You were saying in your piece real quickly that Milwaukee schools were somehow claiming that they were complying with the law by hiding information from parents.
Yeah, I actually think that's the premise of these policies, that we, the school district, know better than you parents about how to respond when your child asserts a different gender identity, and any parent who disagrees is automatically an abuser, is essentially going to hurt their children. And so we have to keep this secret at school so that it doesn't hurt the child. I mean, that's crazy. That's totally inconsistent with how our entire legal system is built. Parents get notice and due process if they're accused of abuse in the Child Protective Services process. There's a very robust process to protect parental rights. And here a school district is just doing it secretly without the parents even being aware. I mean, that's terrifying.
Luke Berg, Wisconsin Institute for Law and Liberty, a pleasure. Thanks so much for joining me.